still managing partner of that law firm.
Thank you. Ask just closer to you, or perhaps to it. You also the muzzle a bit lower. Yes. Now, perhaps if you could go on to narrate the events leading up to. Okay, Honorable Chair, do you want the witness to repeat the last bit of
yes,
earlier response?
It appears that you were hearing her clearly. I was trying to consult IT and answer if they are hearing what you were saying. So the mic was a bit far from you, but now it's okay. I'll bring the mic closer to you. Yes, work on it now. So we can hear.
So for the record, perhaps you could just go on to take that last bit from when you were trained as a legislative drafter at the Kenya School of Law.
I was trained as a legislative draftsperson, Kenya School of Law, and various other institutions. I eventually became parliamentary counsel, head of the drafting department, responsible for the drafting of all legislation. I became Solicitor General in 1991, I believe. Solicitor General and Legal Secretary, to be precise, which meant I was permanent secretary of the Ministry of Justice, as well as legal officer, assisting the Attorney General. And my services were terminated in March 1995. I started my own law practice same year as a sole practitioner, eventually go into a law firm, managing partner of the law firm.
Please cast your mind back to early 2017, before the setting up of the commission dubbed the Jammeh Commission. And please enlighten this committee of how it came to get involved with the Jammeh Commission.
I was invited by the Attorney General and Minister of Justice at the time, Abubakar Tambelu, to become the lead counsel of the Jammeh Commission. And after consideration, I accepted the position.
You say you were invited to
discuss.
It was an in-person.
Yes.
So presumably at the Ministry of Justice.
Yes.
Okay. And the offer was made to you whether you would consider being lead counsel to an impending commission.
Yes.
I do not want to delve into the nitty-gritties of that conversation, but I would like to know the nature of the conversation, in the sense, what were you told would be the mandate of that commission at that time?
So I believe that court action has been instituted in the High Court. In relation to the former president here, Jammeh, in connection to matters relating to public institutions, and that the decision has been taken that the matter was better pursued by way of a commission, a presidential commission of inquiry. And as such, the ministry was in the process of setting up the commission of inquiry. It was respond to, I believe, instructions from the president, and counsel was needed to assist the commission.
Were you ever enlightened on who the subjects of the commission would be?
I was told it would be the president and his family. I think at the time that was what I was told.
And issues like the score, but they was not discussed. That didn't meet.
I believe it was. The scope was discussed. But what I understood was that it was matters connected to the High Court case as formulated.
Were you shown these proceedings? Documents related to the proceedings?
I think eventually I will see it.
Did you have any observations or reservations at the time of this discussion?
The minister, I believe the reservations in the nature of what perhaps your question is more precise. Can be more precise?
Any such observation?
Not that
Or
I.
reservations? At the
Reservations as what expressed to the Attorney General?
yes, from your discussion.
I think I did draw to his attention the fact that I think I was counsel. I believe in my statement I was counsel to at least two of the organizations mentioned, the public enterprises mentioned. I had been counsel to one. It was Social Security, and my retainer was terminated in 2010. And I continued to be counsel to Ocean Bay, and these were subsidiary institutions owned by Social Security, Ocean Bay and Sun Beach Hotel. And I was also counsel to Gamtel, but I'm not sure whether we discussed that. Generally, I think Gamtel and Gamsel, those were the organizations I was counsel to. We discussed it generally, and the understanding was that there was no apparent conflict of interest. However, the conflict did arise in the course of the investigations by the commission. It would be discussed as at that time. But I'm not sure now whether it was in the first conversation or subsequently after, but most likely after I accepted the assignment.
That's a point of interest to the committee. I would ask, when was this meeting held?
I think we met before I was engaged. So I was engaged by letter. I think the date is in the statement that I gave. Yes, before the formal engagement. It must have been before formal engagement.
Can you recall what time?
I started work on the 17th July, as I have indicated in my statement. So this discussion must have taken place within the weeks leading to the 17th of July, 2017.
Narrow within the weeks.
I'm afraid not.
Is this something that you ascertain to the committee on a later date?
The conversation, the meeting. No, I cannot give you precise dates to when we had a meeting.
What about the time?
It must have been end of June, early July.
And of course, after that meeting, a few weeks later, as you stated, a letter was issued to you.
Yes.
And this letter was issued to you on the 12th of July 2017. Honorable Chair, remember I'm referring to MOJ 3B. If the Secretariat could afford the witness with MOJ 3B. 3B. For expediency, I have a copy here. The Secretariat to show you.
I have read it.
Okay. So you were then issued with a letter dated the 12th of July 2017.
MOJ 3B is dated 12 July 2017. It's a letter from the Ministry of Justice, Attorney General's Chambers and Ministry of Justice, to be precise, addressed to me.
Were you given a TOR? Or did rather a TOR accompany this letter?
No,
What were the accompaniments of this letter?
it was not, as far as I can remember. It wasn't accompanied by anything else.
What about the mandate of the commission or the establishing instrument?
Kindly familiarize yourself with the Commission stamps of reference. It's a guide to your work. The Commission stamps of reference were published as legal notice. It was not attached to this letter. So I assumed, the letter assumed that I would take be aware of it.
And upon issuance of this letter, were there subsequently any terms of reference developed
Terms of reference for
for your work as lead counsel?
an engagement letter was developed. When our services are engaged as counsel, we prepare engagement letters. So an engagement letter was developed. It was shared with the ministry. It was subsequently agreed, and which I sent to the ministry for signature. It was signed by the Solicitor General, dated and returned to me. And those serve as the terms of reference as you state for my work.
Great. Before was there any document from the ministry that perhaps would steer you to your role?
No, but we had copious, comprehensive discussion. And the role of counsel to the commission is one that I was familiar with. So, but I didn't have, to be specific, I didn't have any document from the ministry. I did say that I will develop the engagement letter and share it with the ministry, and that's what I did.
You mentioned that the role is a role that you're familiar with. Can you kindly enlighten this committee on what you mean by that?
The role of counsel to a commission of inquiry as a legal practitioner of some experience. I had worked at the Ministry of Justice for 14 years. And during that period, commissions of inquiry had been established. That is why I was familiar with what was expected of me as legal counsel for public counsel to the Commission of Inquiry.
And that's precisely why it was comfortable for you to spell out that role in a letter of engagement, was to fill the void that was created because there were no terms of reference.
There was no void created. When you appoint your lawyer, you don't send the lawyer terms of reference. You tell the lawyer the subject matter in regard to which you needed the lawyer's services. And it is routine for us as lawyers in private practice that when our services are retained, we develop an engagement letter so that the client is aware of the scope of the work we can carry out for the client. This is routine. These are called engagement letters, and they form the basis of the contract between us and the client.
Thank you. I would like to spend a bit of time on this point. See, I can appreciate that for private work that you do for private individuals. But this is a ministry of justice representing a government, a specialized ministry at that, that reached out to you for a specific job. The role was known to you, as you said, from your observations of other commissions. Please enlighten this committee, with the benefit of both your private and public experience, whether the procedure of using engagement letters to engage government on an activity that is highly defined, especially defined by the legal notice, which is legal notice number 15 of 2017, Honorable Chair MOJ 2, whether that practice is appropriate when dealing with a public institution or a public activity such as the Commission of Inquiry. Please enlighten.
Your question is whether an engagement letter is an appropriate document for a public institution. Yes, it is.
Given the nature of work of the commission, the role of a lead counsel is pretty defined. Wouldn't you agree with me?
No, it's not defined, and it doesn't have to be. It's just like every lawyer, every counsel appointed by the Honorable Attorney General. You appoint your lawyer, you give the lawyer a brief, and what the lawyer needs to do is guided by the lawyer's profession. So no terms of reference, no term TOR is required. The reason why the engagement letter is prepared by lawyers when they are instructed is to set out the terms on which the lawyer will carry out the work, and to also ask, because it's a contract, there are terms to the contract, so there would be no misunderstanding. That's one. Secondly, it's also to indicate the scope of work that the lawyer can carry out vis-a-vis the engagement. And it is the lawyer who sets out the scope of work, and in doing so, the lawyer indicates their understanding of what they are being asked to do. No lawyer asks the client to send them an engagement letter. It is the lawyer that prepares the engagement letter. And it's not peculiar only to lawyers. Accountants do the same, because we understand what we're being asked to do. So I understood the implications of what I was being asked to do, and I set it out as it's our practice, and it's normal practice, in an engagement letter, which I sent to the Attorney General.
I'm curious, Ms. Bensouda, who were you engaging? Who was your client?
The Attorney General, acting for the government of the Gambia, was my client.
Please enlighten me. Would you say that a commission inquiry is dependent on a government, or would it be an independent institution?
What a commission of inquiry is has been defined by the Supreme Court of the Gambia in the case of Ferial Ghani. And in that case, the Supreme Court stated that the commission of inquiry was part of the executive, which is the government of the Gambia. However, in the conduct of its work, it is independent and it has powers. But as far as what a commission is part and parcel of the government of the Gambia.
Of course, it has to belong in the grand scheme of things to one of the arms of the government. So it belongs to the executive arm. I would agree with you. My question is...
No, I didn't say that.
I didn't say it has to belong. A commission is issued by the president in exercise of his powers under the Constitution. He issues the commission to carry out a certain work for him as president of the country. And as I said, I think I do have the case if you're interested, which precisely indicates what the Supreme Court said a commission of inquiry is.
Not now, Ms.
Okay, I was going to read it for you if it's relevant, perhaps.
Just to enlighten you, I actually put this same case to the Doyen when he was here. So we are well aware of it. But out of courtesy, I will take the case from you eventually.
No,
and
if you have it, then I don't need to give you a copy.
great.
But I thought it was important.
Because you asked the question. And we are lawyers, and I don't have to reinvent. I don't have to reinvent an answer for you, because the Supreme Court of the Gambia has already set out what the commission is and is not. So the commission is part of the executive arm of government.
So the answer to my question is that your client was the government and that the commission is part of the government, correct?
The commission is an extension of the government of the Gambia.
That's fine.
And
It's
perhaps,
interesting
and
that
I was appointed by the General acting on behalf of the government to assist the commission.
Yes. It's interesting that you mentioned that commission by the president. And of course, the nature and structure of commissions of inquiry are spelled out in law. You would agree?
It's spelled out in the Constitution.
In the Constitution and in statute. Would you agree?
It's spelled out in the Constitution. They previously were spelled out in the Commission of Inquiries Act. And then when the 1997 Constitution was enacted, It has a whole chapter relating to the Commission of Inquiry, and that chapter overrides what is in the Commission of Inquiry Act. But together, they constitute the law that guides commissions of inquiry in terms of both their appointment and their operation.
So the Commissions of Inquiry Act would govern commissions of inquiry, wouldn't it?
The Constitution would govern commissions of inquiry, and where appropriate, in respect of any matter that is not in the Constitution, reference should be made to the Commission of Inquiry Act.
So the Commission of Inquiry govern commissions of inquiry.
I wouldn't put it quite like that, because the Constitution is the overriding law, and therefore the Constitution would govern commissions of inquiry. But where
my statement to the Constitution. My question is whether, with regards to the operations, the setup of commissions of inquiry, would the Commissions of Inquiry Act be a relevant piece of legislation to reference?
it is relevant where there is a gap in the Constitution.
And I know no inconsistency with the Commissions of Inquiry Act and the Constitution. Perhaps if you do, you can enlighten us. I take it there's none. So both legislation govern commissions of inquiry. Now, it's interesting because
Learned Counsel,
yes, yes.
with due respect to you and your standing in this August committee, I am your witness, you are the lawyer. I answer the questions.
Is that it?
My answer. Constitution is the prevailing body of law that you refer to when it comes to commissions of inquiry, that apply to commissions of inquiry. But if there's any aspect of a commission of inquiry that's not in the Constitution, reference is then made to the Commission of Inquiry Act. You would have observed that the Constitution covers, in many respects, what is already in the Commission of Inquiry Act, in terms of how a commission can be issued, in terms of how it can be constituted. So with regard to all those matters, you refer to the Constitution. And with regard to any other thing that is not in the Constitution, you refer to the Commission of Inquiry Act. That's my answer.
Thank you for your answer. My question is, with regards to commissions of inquiry, the Commission of Inquiry Act is relevant, isn't it?
It is relevant.
Thank you, Ms. Bensouda. That's all I wanted. Now, once quick perusal of the Commissions of Inquiry Act would reveal the functions of respective personnel within the Commission of Inquiry as set out. Would you agree? Would you like to be furnished with the Commissions of Inquiry Act before we thread on this line of question?
Certainly, if you're going to ask me specific questions on the Commission of Inquiry Act, I would like to be furnished with a copy of that.
The witnesses will be furnished with volume 5 of the laws of the Gambia. While we wait, Mr. Bensouda, catch up on whatever we have lost, can you please take us through MOJ 3K, which is your engagement letter? It's dated the 24th of July, 2017. If you do not have a copy, one will be furnished to you. MOJ 3K. Would you like a copy or do you have one?
I have my own, which is not numbered as MOJ 3K, but I'd rather use the exhibit that you have as MOJ 3K. Thank you. I see it.
Yes. Please take us through it.
Want me to read it?
You don't need to read it, just give us the essence.
MOJ 3K, which is dated 24 July 2017, is a letter emanating from my law firm addressed to the Honorable Attorney General, Minister of Justice, and copied to the Solicitor General and Legal Secretary. It is the engagement letter and commission of inquiry into the financial activities of public bodies, enterprises, and offices as regards their dealings with former President Jammeh and protected markets. It says, thank you for your instructions in a letter dated 12 July 2017 in relation to my appointment as lead counsel
You need not read it.
in the above-mentioned commission of inquiry. I write to confirm the basis on which I have agreed that I will act as counsel. So what is set out in MOJ 3K is the basis on which I had agreed with the Honorable Attorney General that I would act as counsel. So it captures the scope of work. The scope of work is divided into three areas. One is the management and administration of inquiry processes and procedures. And here I set out what I understood that I would be required to do or oversee. And two is the investigation process and the correlation of the evidence. And again, it sets out what I'm required to do, what I understood by the instructions that I was required to do. And three covers the proper and effective conduct of commission hearings, whether in public or private as appropriate. So each of these areas are itemized and set out extensively that I understood that my engagement would require. The rest of the engagement letter sets out my duty as client, as lawyer to my client, whom I consider to be the Honorable Attorney General, the team that I had put together. And I had indicated as at that time, senior associate from my office would be joining me, the person of Miss Anenjai. The second part sets out the fees and expenses that was agreed, the fees that was agreed, that expenses perhaps that I would incur. The fourth part indicates the responsibility for advice and services. These are a caveat, usually putting all the details and my signature.
Thank you. I'm contending with who was engaged here, and you have clarified that it's the Honorable Attorney General. But this seems like an engagement from your firm. Is it your firm that engaged the government of the Gambia, or is it you as Miss Amie Bensouda? Amie Nyundu Jammeh Bensouda, if I may say.
Thank you. I was engaged by the Honorable Attorney General in person as counsel. Engagement of counsel is usually personal, but I work for a law firm, and this was also taken into account. The law firm would give me support, but I was engaged in my personal professional capacity.
I'm still not clear on, you were engaged in your personal capacity, you just stated, correct?
Yes. I was appointed by the of 12 July, MOJ 3B, in my personal capacity as lead counsel, to be lead counsel to the commission.
It's because of MOJ 3B that I'm contending, or rather, I am struggling to understand the need for an engagement letter. I'm trying to reconcile the two. Perhaps you can assist.
Perhaps if I understand what the
The
nature of your misunderstanding is.
Sure. You are appointed to hold a public office, which is the office of the lead counsel to the Jammeh Commission. And to that effect, a letter was issued. And the letter spelled out your role, which is to be lead counsel. And of course, the TOR, so rather the legal notice, the mandate of the commission, would spell out the mandate of the commission, and you were to act as the lead counsel for that commission. What my contention is why there was a need for an engagement letter.
Just to clarify, firstly, the premise of your question. The lead counsel was a service, it was not a public office. It was a service that I was appointed to do, not a public office.
Okay, I'll contend with that.
If it was a public office, it would be in the government, listed out in the government establishment as a public office, but it's not. The reason being, commissions of inquiry are ad hoc instruments that are created by the president as needed. And if you look at the terms of reference of the commission of inquiry, you will see that at the time of legal notice by which the commission was issued, authorized the Attorney General to appoint counsel to assist the commission. And it's pursuant to that authority in terms of reference that the Honorable Attorney General appointed and instructed me to act as lead counsel. As I have explained, the Attorney General has the power, not only because he was instructed in the commission issued by the President, but as law officer under the State Proceedings Act, under the Legal Practitioners Act, to appoint counsel with regard to any proceedings. And there are no TOR for such counsel. Such counsel, when appointed, are not public officers. They are instructed as professionals to carry out a function. And all lawyers so appointed, we serve and I serve as a lawyer to the government appointed by the President for a particular purpose. I was not a public servant. Secondly,
If I may just correct the record, Bensouda, I did not say you were a public servant. I said you occupy a public office.
okay, I did not occupy a public office. I was not appointed to any public office. My attention was not drawn to any public office called lead counsel. I was told the commission was being appointed. Counsel was needed, and would I serve as the counsel? I was appointed by that letter of the 12th July, and I set out in an engagement letter to be signed because I needed a contract. Precisely because it's not a public office, it's not subject to any rules that apply to public officers. I needed to have a contract, and that contract would circumscribe what I am expected to do, would govern the expectations on both sides as to what I'm undertaking and the terms on which I would undertake it. That is the purpose of the engagement letter. Without such an engagement letter, the appointment would be at large, because there is no office called legal counsel, lead counsel. There is no establishment rule or any other public instrument that would govern my role, as opposed to if I was state counsel, for instance. So I needed an engagement letter. And it's that engagement letter that formed the basis of my relationship with my client. My client was the Attorney General acting on behalf of the government.
Thank you. You had just mentioned that the President issues a commission for a specific purpose. So, by your own admission, the role of the commission, there is no doubt in that. There's no doubt in the role of and mandate of the commission. And there's also no doubt in what you are appointed as per MOJ 3B. You are appointed as lead counsel. Correct? Am I?
By the terms of reference, set out the mandate of the Commission of Inquiry. Yes, I agree with that. The terms of reference set out the mandate of the Commission of Inquiry.
And I've also, as you already know, seeing that I believe you were in this matter, that the Supreme Court just made a ruling, or rather a judgment, in the Ibrahim Diba and United Democratic Party case just 2 years ago, in 2023. I can afford you the judgment, but I'm sure you've read it. And it defines what a public office is. And for all intents and purposes, a public office is an office of which the emoluments of which are charged under the CRF, the Consolidated Revenue Fund. I find it difficult to exclude the office you held as lead counsel from that definition. if you could enlighten us how such an office would escape that definition.
That
is also a constitution. The pronouncement of the Supreme Court was based on the Constitution.
Well, without asking you to be specific, my answer, do you have the judgment with you?
I do.
Do you have the judgment? Yes. Could you read out what portion of the judgment you're talking about?
Certainly. With your permission, Honorable Chair. Honorable Chair, am I permitted?
If the judgment is relevant to what we're discussing, I'm not too sure. But that was just for you to reference
Exactly.
the judgment made by the Supreme Court
Exactly.
as to the definition of a public office. So I think that was all that he was trying to do. I'm not too sure that was relevant to the work that we did. But then, like you said, the office that the new council was appointed to, if the definition you said that any office that is charged from, the emoluments are charged from the CRF, is considered to be public office. I think they know that.
Well, what I could say, Ms. Bensouda, is that in any case, it will be a back and forth between you and I.
I certainly will not engage in a back and forth with learning council.
I wouldn't.
But you are referring to a judgment.
I would make it.
And if you have a judgment and you want to refer me to a portion of the judgment, because my understanding of that judgment is different from yours.
It is indeed.
Now,
what I would do if I could just direct, Ms. Bensouda, if I could just direct that the judgment would be availed to you. You are the committee's witness for another 2 days at least. We will have ample time to deal with whether or not my position is right or wrong, or whether my interpretation is factual. And you can bring it at any time. As for this time, perhaps we can move on, and you can raise it at any other time once you've been furnished with the judgment.
I do have a copy of the judgment.
Okay.
What I'm saying is you are drawing attention to a decision of the Supreme Court, which is in the judgment. There might a portion of the portion of the judgment which supports your contention. Is what I'm concerned about, because I have a completely different understanding.
Right.
When the Supreme Court talks about public offices charged, whose emoluments is charged, it means these are public offices that are created by the government establishment budget, and it's an office in the government establishment budget, or it was created. And let me finish my answer. Let me finish. Let me finish my answer. I'm not engaging in a back and forth. I'm telling you what my understanding is.
I would be inclined to tell you my understanding, and that would certainly take us to a back and forth. Because if you express, yes, Ms. Benson.
You have to assist the committee.
Indeed, you are.
You're asking me questions.
Yes.
I'm the one who should answer your questions.
Yes.
Certainly, when it comes to a matter of law, we can agree to differ, because I'm not here as a witness of law.
You're here.
I'm here as a witness of facts.
Indeed.
But if you put to me, as a lawyer, your own understanding of a judgment which I do not agree with, I have every right